and then there's two lines that are crossed out, that only your feelings matter, screw mine. And then on the side of the page is written, the evil seeped in and corrupted you beyond recognition. One of the other excerpts is now from Exhibit 18, and that is the purple notebook. I hate being alone. I hate you for all the lies, exclamation point. You don't love me, exclamation point. This is not love with not underlined. And then on the next page, at the end of a longer entry, is written, and I know what cunt face meant by challenge, in quotes. Have fun with the shithead AIDS victim she brings home. I will never be in competition with her. She'll lose every time in every way. Thank you, Judge.
And with that, does the Commonwealth rest?
Your Honor, the Commonwealth rests.
All right. Jurors, I'm going to excuse you very briefly while I chat with counsel, and then we will proceed with the defense case, or at least the beginning of the defense case.
All right.
And jurors, I think we'll treat this as the morning recess, because I think that we'll be able to go through whatever defense witnesses we have and let you go after that. Thank you.
No, it's not.
Judge, Mr. Scully will argue for us on the motion for required findings.
Yes.
Second session, you can see the sound all cell phone.
Go for it. Yeah, you do it. No.
And approach clerk to file.
Yes, you may. Mr. Scully, I just realized I didn't turn to you after Mr. Camelio finished and asked, did you want to read any excerpts, which I will still permit you to do if you wish, but I should have asked you formally, and I just forgot.
That's okay, Judge. I was trying to figure out what, if any, excerpts I might read. Couldn't figure them out, so I was going to pass on.
Okay, that's right. I apologize, though, for having neglected to formally ask you. Mr. Scully, I will hear you.
Well, I don't think there's much to add. I know the court has been following along very closely, taking its notes. I think the case has come in the way primarily the parties predicted that it would come in their opening statements, and the prosecution has, introduced a circumstantial case which I feel, which I would submit to the court, doesn't prove anything beyond a reasonable doubt. We don't know what happened to Leroy Fowler here. There are multiple possibilities. I would suggest there are several that don't outweigh each other. And I would ask that if the court makes a ruling, that it does so in writing on this rather than, directly, and I would waive further argument.
All right. Well, I'm not going to make a ruling in writing. I can almost never recall having made a ruling on a directed verdict motion in writing, even when I've granted motions in whole or in part. I am denying the motion. It's construing the evidence in the light most favorable to the Commonwealth, as I'm required to do, and drawing all inferences, reasonable inferences, in favor of the Commonwealth. I find that the jury could determine beyond a reasonable doubt that the Commonwealth has proved all of the elements of the charge of murder in the first degree by both theories, that being deliberate premeditation and extreme atrocity or cruelty. I don't really think I need to say more beyond that, but that sufficient evidence has been presented by which the jury could find that there was a deliberate intention on Ms. Church's part to poison Mr. Fowler with some ethylene glycol substance, and that the manner of doing so ended up being a killing with extreme atrocity or cruelty because the time frame, the various stages that Mr. Fowler went through, basically what a prolonged death this ended up being. So I deny the motion for directed verdict. I preserve Ms. Church's rights with respect to that ruling, and I'll say nothing further on that. The defense is presenting what witness or witnesses today?
Judge, we just have one witness today. It's Michael Kahn
Michael Kahn, all right.
from MCR Labs.
Okay. Then before we give you, you all the morning recess, and then we'll hear Mr. Kahn and we'll recess for the day. Let me just take up something I neglected to take up the other day, which was that Exhibit N. This was a thumb drive that contains a video, which I viewed. I'm sorry, it was Exhibit P.
Was
right?
the thumb drive? Yes.
Yes, Exhibit P, okay. Which contains a video set to music. There were, by my viewing, 14 photographs and 3 either videos or moving photographs of Ms. Church and Mr. Fowler together in various locations. In a few photographs, their dog is with them. From the way that Ms. Church and Mr. Fowler are dressed in the various images, it appears to me that, and there are 17 separate photographs or moving photos or videos, it appears that they were taken on 6 different occasions, as far as I can tell. The video is 42 seconds in length. Mr. Scully, what is the theory of admissibility on this, and where did it come from?
So this, there was testimony about this. I cross-examined Trooper Williams about when he searched the phone, and he was, through the prosecution, introducing various excerpts and photographs and the like that he found on the phone.
Right, and he didn't see the video because he didn't think that a video of this sort, he hadn't seen it, was within the scope of the search warrant. So
I don't think he testified to that, Judge. I think he was.
He actually said that. He said, "I don't believe I saw the video. It wasn't, I couldn't search for just videos like that."
I think he saw the video and was familiar with it and overlooked it. That's my sense, Judge. I don't.
Your sense from what, Mr. Scully?
That's
From
my
what he
recollection
said
of
on the
testimony.
stand?
Right. In other words, the limitations to the search warrant that was for text messages and data and the like is not the same limitations as for photo and videos. They obtained a different search warrant for photos and videos, is my recollection, and I'm not aware of any restrictions to them. He didn't have a clear memory, is my memory of his testimony when I tried to cross-examine him of the video. It wasn't, so my point is this goes to the police bias in the investigation, that they are willfully overlooking evidence that showed the positive relationship, the loving relationship that did exist throughout the years between Judy and Leroy. And they're cherry picking things from, years past, 2000, at least 18, 19, 20, 21, from various sources on the phone, these little constellation points, and now trying to put them together on that evidence table up there, while completely turning a willful blind eye to some basic information that there was that I think the title of that video was Together Through the Years, so it seemed appropriate because it shows a span of time and the loving relationship in a softer light than the one than just the text messages, which are more of an explicit nature that also came in through Trooper Williams.
All right. I understand the theory. I'm just looking back at my notes, what I took down in response to what he said, and what I had him saying, this isn't a direct quote, but it was my understanding of what he said, was that he wasn't permitted to view it, and he couldn't say that it came off the phone. So if it's a Bowden theory that this is evidence that they overlooked of this loving relationship, I don't think there's an evidentiary foundation for it. But what's the Commonwealth's position with respect to this? You objected, but I didn't ask.
I do, Judge. This is my understanding, based on what I've seen on that disc, that I don't know how much the court knows about iPhones, but iPhones have, some capabilities to sort of create these things just sort of on their own. They it's a way to show you your memories.
I'm not that much of a Luddite. Mr.
No, I didn't mean that, but this is something I didn't know.
Enjoy them. My phone creates them, and all of a sudden I'm looking at the stroll down memory lane.
Right,
so yes, I enjoy them.
So I didn't. I'm not. Maybe I'm more of a Luddite than you. I really depend on Mr. Asnick for my technology education in this case, but and Trooper Williams for that matter. But this is I don't know, Apple creating this thing for you to sell you and keep you invested in the Apple ecosystem. I don't think that so the fact that it wasn't created by Miss Church, so it doesn't show her view of the relationship. It doesn't go to her state of mind. It goes to the things that Apple has cherry picked out of her phone.
Well, I don't know. It may have been Apple. It may have been Miss Church. I don't know. There's no evidentiary basis to tell me one way or another.
That's fair. And my memory of the testimony is the same as yours. That Trooper Williams said, or Sergeant Williams, I keep demoting him. Sergeant Williams said that no, he didn't have a recollection of having seen that. The search warrant itself, Judge, was the second one that was done in this case, and the specific videos that he was allowed to look for were videos depicting Powerade, soda beverages, coffee, milkshake, or toxic chemicals. Otherwise, he was limited to that November 11th, 2022 date.
Well, that's what my notes reflect. He was saying when he said he didn't believe he saw it because he thought it wasn't within the scope of the videos that he could search for.
I do think there is some danger here that the way we've been discussing this, because there was a general motion to suppress these search warrants, and obviously denied, but some of the issues of plain view for the trooper were never, that was never raised with respect to things that were found. So, I just don't want there to be a, sort of a question on appeal, if it ever gets that far, that this is sort of a live issue based on that motion to suppress. That was not litigated in that sense. So I don't see that as a live issue. But I think what is important for the admissibility of these documents is right here is that, as the court said, there's no evidence that Trooper Williams ever saw it, so he couldn't have considered it for purposes of Bowden, and there's no evidentiary foundation for saying how it got on the phone, who made it, was it technology that did it without anyone knowing it was there? Was it Miss Church? I stand by my objection.
I'm sustaining the objection for the reasons I've said. There is no time frame on the on the video or the photos, but that wouldn't be necessarily an impediment to its admissibility because, for example, if Ms. Church were testifying, just as Mr. Scully points out, the Commonwealth has cherry-picked certain texts and whatnot from going back to 2019 to try to portray the relationship going back some period of time. I would certainly allow Ms. Church to testify that this was a loving relationship and talk about, these photos reflecting that, whether it was back in 2019 or 2020, 21. I would certainly permit her to do that. I think she was able to express that view fairly articulately and forcefully a number of times in that recorded interview I saw, where she stated over and over again that she loved Mr. Fowler. But in any event, and I'm not certainly suggesting that Ms. Church needs to testify in order to authenticate this video and admit it, but I would have permitted that because she would be the proper person to do that and explain, because Trooper Williams really couldn't and didn't. So that's my ruling with respect to that.
I have another grounds I'd like to raise for the record, Judge, which is a due process grounds, which is that we know this phone was taken from Ms. Church. We know this video was on this phone. There's no dispute. The Commonwealth is painting a very one-sided, as is its right, and limited view of a relationship. In our view, taking it out of context in order to serve the purposes of the prosecution. The defense has a right to put in evidence to broaden the scope of the jury's view. That's our right to put on a defense and to show that there's much more to the relationship. This particular video, which is short in nature and was on her phone, was there in plain view for the police to look at through the search warrant or not. You've made a ruling relative to Bowden. But now I would move to introduce this pursuant to our due process rights to put a defense on, and that this piece of evidence is a fair counterbalance to the misleading picture that the prosecution has tried to show throughout this case, including by putting together reading in journal entries from unknown times about their relationship, phone notes from unknown times about their relationships, and various photographs and other evidence, text messages and the like, and statements from other witnesses. So this is our due process moment to put that one piece of evidence in, or this particular piece of evidence in, to help counterbalance that, and to corroborate also what Judy Church did tell to the police about the loving and good nature of their relationship. She did testify, or not testify, but she did tell the police in her interview that she loved this man, that he was his world, and that she would not harm him and did not harm him, right? And this video is a crucial piece of evidence to show that that's just not a statement of self-serving interest. Here's a short video set to music on her phone that really captures, in a unique way, a long relationship that went on for many, many years.
I understand the argument. I don't think this fits within the parameters of the very narrow due process constitutional hearsay exception, and it is a hearsay exception. It's generally not just a broader due process exception, but there's a few components to it, and one is the evidence has to be fundamental to the defense and not available through any other source. The case law under Drayton is the case, but the case law under that particular exception even makes clear that if, for example, the evidence sought to be introduced pursuant to the exception is available if the defendant testifies, that's a factor cuts against its admission under the due process exception. I don't find this evidence to be fundamental in any manner. The fact that there would be some loving photographs of Miss Church and Mr. Fowler together, who spent at least 8 years as a couple, is hardly surprising, and it's really neither here nor there as to what the exact nature of their relationship was on November 11th, 2022. It might be helpful to the defense, but fundamental it is not, in my view. And so I don't find that exception applies. So I stand by my ruling and I preserve your rights.
And just to clarify for the record, Judge, I don't view this as a hearsay issue because I don't think that the music is being submitted for the truth of the matter or the photos or words on the songs.
And I don't view it as a hearsay, but the due process right that you're noting is generally one that's been characterized as an exception to the hearsay rule. That's generally why it's coming in.
I think of it in this terms. We have the right to call witnesses pursuant to the due process clause.
Yeah.
We have the right to introduce exhibits pursuant to that clause. In my view, we have the right to introduce this exhibit under that, broad and most powerful right. We don't have this right in our due process. So that's where I'm looking at it. And I don't think hearsay is there because we're not introducing this to show the truth of any of the words on the songs.
I agree. It's not a hearsay issue.
Right.
I agree with
It's a state of mind issue.
But I stand by my ruling for the reasons I've articulated.
Okay.
Now I'm going to let people have a break, and then we'll come back and hear the one defense witness who you're calling tomorrow.
So can we talk about that at sidebar in a few moments, Judge? I want to confer with Mr. Norkunis.
Well, I'll let you take the break, but before I let the jury go, I want to know exactly where things stand for
Things are
tomorrow.
shifting.
I'm sorry? Things are shifting.
shifting.
All right, so please, and by the way, I generally will have a colloquy with any defendant who's choosing not to testify. So it's your expectation at this point that Ms. Church will not be testifying?
I think that would be a decision that would be made between today and tomorrow.
Okay. If tomorrow morning you tell me that Ms. Church is not testifying, then probably before we bring the jury in, I will have that colloquy with her about her right to testify. And if you tell me she's testifying, that's fine, and I'll forego it.
Right. I think that issue, actually, as we've been trading issues, is it going to be a Mr. Narkunis issue?
Okay, that's fine. All right. We'll take our morning break.
Court will rise.
Mr. Scully or Mr. Norkunis, did you get a sense of what tomorrow looks like yet?
I would say that is going to be under discussion, Judge.
Okay. Is there at least one witness you know you're calling tomorrow?
I think so, yes. Still under discussion, but we have one that I don't think we're going to change our mind on for sure, Edmund Crouch. And then there's Dr. Lake. And so the same witnesses we've been mentioning to you. And then the issue of whether the defendant testifies, of course.
Okay.
So, but
And the Commonwealth's rebuttal, is that dependent on what the defense does?
Yeah, yes.
I think that depends on today. This is,
No, it depends on Celeste Wearing.
yeah, so I don't think, I'll talk to the prosecutor and make a final decision. I don't think we're going to call Celeste Wearing.
Okay.
Medical examiner testified that denatonium benzoate is the most bitter substance on earth. That came in. That seemed to be a source of, on direct exam, I think. That came in, and that seemed to be one of the issues with
No, it
Celeste
didn't come
Wearing.
in on direct exam. I don't think Mr. Camelio elicited that. Mr. Norkunis did on cross.
I forget which one, but it's in. So
It isn't.
that
And you
issue
said
is
that.
no longer one that we feel we need to address with a particular witness, and that was primarily Celeste Wearing as a toxicologist to testify about the nature of that substance and educate the jury that way.
Okay, well, that's fine. So you don't believe you're calling Celeste Wearing.
That's my current belief. I want to revisit that, but
Okay.
that's my current belief.
And if that plays out, Mr. Camelio, you wouldn't be calling your rebuttal witness.
Unless somebody else says something.
Okay,
That,
all right.
but that's the expectation.
All right.
Awesome.
Billy, good to go. Come right in. Good to go.
There it is.
Mr. Camelio, are you doing the closing?
Yes, Your Honor.
And Mr. Norkunis?
Yes.